Good argument on both sides. Thank you very much for your hard work on this. We will next consider the case of Department of Families versus KD. And for the information of those who are here, after this case, we'll take our mid-morning break and we'll invite all attorneys present to join us in the attorney's lounge for coffee.
Good morning, Your Honors. May it please the Court. I am Deborah Schroth, and I am here appearing on behalf of the State of Florida, acting through the Department of Children and Families. I'd like to reserve 7 minutes for rebuttal time, if I may. Before I get started on my argument in chief, I would like to make 2 corrections to our briefs. In our initial brief, we have an incomplete citation to the appendix. On page 19 of that brief, the appendix citation should read Appendix 3, page 2. There is a substantive correction in our reply brief on page 9. We stated that Amici made similar constitutional arguments in the TR case as they made in this case, and that's inaccurate. We should have said that they made similar statutory arguments. The constitutionality of the statute was not involved in the TR case.
What was the first reference, the appendix reference? What was that to?
On page 19 of our initial brief, Appendix 3, page 2.
Thank you.
Okay. The Department wishes that KD had been eligible for independent living benefits. In the answer brief, in the Amici brief, we hear about how she's deserving and children like her, youth like her.
If you hadn't filed a notice of appeal, she would have been.
The parties are saying that KD deserves these benefits, that KD should be able to benefit from the independent living program. And the department wishes that it could provide those benefits to her. But the problem is the department has to administer statutorily created programs in accordance with the statutes. We are not free to deviate from the statutory requirements because then we would be acting arbitrarily and capriciously. So the statutory issue involves the fact that there is a peculiarity, a shorthand in language that's used within the child welfare program in the state of Florida. And everyone uses this particular shorthand. And the shorthand is to interchange the term foster care with the term licensed foster care. When you look at the definitions in Florida statutes, and you have to look in the dependency, Chapter 39, in 39.01, there is a definition of foster care, and that definition lists all the types of homes that can be licensed by the department. The only other definition that relates to placement type is in Section 48 of the definitional statute, and that talks about out-of-home care. And essentially in the construct of child welfare, out-of-home care is every possible placement for a child once the child is removed from their parents.
Including foster care.
Including foster care. Out-of-home care can include foster care, and then we have foster care. Foster care equals the custody of the Department of Children and Families. A child only goes into foster care when a child is committed to the legal custody of the department. And then once we have legal custody of a child, we are only free to place that child into licensed foster care.
Now, isn't that really the only distinction, really, as far as what happens with the child once they're in out-of-home placement is that they're just in the care and custody of the department, and the department puts them in foster care. But otherwise, you know, as far as being situated similarly or not, but I'm saying similarly, they can be put in non-relative placement with a stranger. Isn't that true?
Non-relative placement is not with strangers.
So there's so you're saying to the court that you don't place children in non-relative placements where they're with someone other than a friend of the family?
That is correct. That is correct, Your Honor. The only time that the department, well, first let me step back and say the department suggests placements to the circuit court, but it is the judge who actually places and enters the court order as to where a child is going to be located.
So let me rephrase my question then.
Certainly.
So are there situations where a child is placed, and the whole issue I'm concerned with is the placement as far as their entitlement. So are there situations where the child is placed, whether it's by the court based on recommendations from the GALU and whomever, in non-relative placements with strangers?
Not that I'm aware of, Your Honor. No. The point to non-relative placement is to allow those families who, for whatever reason, either don't have extended family in the area or who don't have extended family that they think is suitable, to use a friend to be able to provide temporary custody for their child. And in fact, that's exactly what the case was here. When you go through the record, you read that both KD and her sister had arranged their own placements with their friends, family friends, before their mother left to go to California.
But they were also placed, as the record reflects from KD, with someone who was not a friend of the family when the parents were arrested. Isn't that a part of the record as well?
Your Honor,
Down the street, someone, but they weren't friends of the family.
I think you're talking about an incident that must have happened years prior to their coming into care at this point in relationship to this
Well,
case.
it's part of the record is what I'm referring to.
Yes, ma'am. And if someone lives down the street, that person, somebody had to have asked the department to look at that placement and to see if the children could go there. But the department does not look around and just say, oh, the children don't know who you are at all. The mother doesn't know who you are at all. You come on in here.
I understand.
Is it DCF's choice where to place these children?
The department recommends to the court where to place children. The court chooses where to place. And keep in mind that at the dispositional hearing, the child is supposed to have a guardian ad litem, and in this case she did have a guardian ad litem throughout the case. And in this case, after the initial placement of KD, but before her second placement in this episode, she had an attorney ad litem. So it's not just the department making recommendations to the court, but other people acting on behalf of the child as well that make recommendations.
Did the department recommend that she end up in,
non-relative care? Your Honor, the department did. And the department did that at the request of KD herself. The situation with KD...
Well, you see where I'm going here. I mean, if the department was directly involved in the selection of this particular foster care, not speaking in a technical sense, in this particular custodial arrangement, and KD, as a result of that choice by the department, ends up being deprived of a privilege that would ordinarily be given to kids who are in foster care. You know, I think I see where the trial judge was going on this and why he thought the statute might be unconstitutional. That's a very troubling thing about this case, and it's I'm sure the reason why the department would rather see her get the care.
Well, Your Honor, the department would like to...
If you voluntarily dismiss this appeal, we could probably arrange that.
Your Honor, KD
You would
is...
be happy, and they would be happy, and we
Well,
would be happy.
the real problem here, though, is that not only has the legislature said these are the categories of young adults that are going to get these benefits, but the legislature has also appropriated a set finite amount of money For last year's budget, at the time that this case last was heard by the trial
Tell you what
court.
doesn't make any sense to me about that argument is that the department apparently was perfectly willing to solicit this child, and I suppose others, to go into foster care in order to get the benefit. And if Katie had followed your recommendation, she would get this money. And it would have cost the department more money because they would have had to pay for the foster care during the 6 months. So you're saying that we have to protect the money. We're trying to give away the money at a greater cost to the state, and now you're saying, you got to do this to protect the money. I mean, so the policy sort of behind-the-scenes argument doesn't really play.
Well, actually, let me get a little deeper into that then. First of all, we would like to help all of the children that we come in contact with maximize their benefits, whether that would come from the Social Security Administration, whether that comes from within. If KD had been in foster care, then when the department submitted its legislative budget request for what's now the current fiscal year, KD would have been in the number of youth who would have become eligible for Road to Independence and who would be receiving that benefit this year. And so she would have been counted, and the legislature would have known that here's the number. But we can only put in the LBR, the legislative budget request, our projected number of youth who are going to be eligible. And it's not that we're trying to protect the department's money. The big problem here is that the legislature says these are the categories of young adults, and then they say here's the amount of money. That pool of money doesn't grow if the court affirms the trial court's decision and we now have a much larger pool of applicants. So what we're trying to do is to protect the children, all of them, who are clearly eligible for these benefits, who age out of foster care. The children who were our children in the department's legal custody, in the custody of the state of Florida.
But isn't the intent under Chapter 39 for all children that are in out-of-home placement to be treated equally and have the same services available? Isn't that one of the purposes and the intent of Chapter 39?
You know, Your Honor, that is a sticky wicket, that section. And I have to tell you, I've not only looked to see if there was any case law interpreting that, which there is not, but I also went to the state archives to look for legislative history surrounding the adoption of that section, and there is none, unfortunately. But what I will say is that under terms of rules of statutory construction, the more recent statute controls the later statute, or excuse me, the earlier statute, if there is a conflict. That provision that you've just cited from came over from Section 39.40, and it was approved by the legislature in 1992. The Road to Independence statute was approved by the legislature in 2002, and the legislature is presumed to have known what it said before, and yet it still said what it said here. If there was any confusion, and surrounding people interpreting what the requirements were of 409.1451, there have been 3 developments that make it clear that it's meant to be for children in foster care only. The first is the adoption of Section 39.013, subsection 2 of Florida statutes that talks about extended jurisdiction between the ages of 18 and 19. And it specifically talks about determining whether appropriate independent living services have been provided to the, and I quote, formerly dependent child who was in the legal custody of the department immediately before his or her 18th birthday. KD was not in the legal custody of the department, but rather she was in the legal custody of Mary Carmody. We also
How many
have
children a year reach the age of 18 who have not been, who are in the same position, who were not in foster care for 6 months within the year prior?
I'm sorry, I didn't
How
catch
many
the-
children a year do not, are in the same position and do not qualify for these funds because they weren't in foster care for 6 months prior to their...
I did request the department to give me some numbers for the current year, but the number is across the board. It's a little over 500 would be in that category.
You're beyond, if you've asked for 7 minutes in rebuttal, you've got 6
Yes, Your Honor. I think I'm going to shave a little bit of time off of that. I would like to point you to the TR case. The TR case had a very similar situation. TR was a young adult who was also living in a non-relative placement. When TR was just about ready to turn 18, she came to court and requested the trial court to order that she be able to go into subsidized independent living and Road to Independence, and the trial court agreed with that, and the appellate court overturned it. And finally, in 2005, we have legislative history to Senate Bill 1314, and that is cited in the brief, and in fact, that's that appendix citation, where the Senate Children and Families Commission, the Senate Children and Families Committee staff specifically says that children who had been in non-relative placement are not eligible for independent living benefits. As to the constitutional provisions, if the court does find that the statute requires licensed foster care to be eligible for independent living so that you then reach the constitutional issue, the rational basis standard is the standard that you will use to judge the constitutionality of this provision. The department first would have liked to have known that the court was going to consider the constitutionality of the statute. Prior to that hearing, no party had alleged it. Even during the course of the argument of that case, no party raised the issue of the constitutionality of the statute. Rather, the court addressed it sua sponte, thus depriving the department of the opportunity to present testamentary evidence as well as documentary evidence, to provide numbers, to provide reasons. But there are multiple differences in the situation between children who are placed with non-relatives or relatives and children who are in licensed foster care. Yes, ma'am.
Why is it that the department, when the judge says, is there anything else from anybody, the department say, yes, we want to address this constitutional issue and we need more time. Can we continue this, or can we have the opportunity to address this in some way?
I cannot answer that, Your Honor, other than I do know that in that hearing the judge asked everybody to move along because he was in a hurry. Because
that was prior to his last statement.
I don't know. The department did file a motion for rehearing, however.
Yes, and it was denied. I'm aware of that.
Yes, ma'am. Thank you.
Carlisle, we seem to have the entire family here this evening.
Yes, Your Honor. May it please the Court, Chris Carlisle here. As you're aware, the calendar this morning had Shannon Carlisle listed, but I filed a notice of appearance for oral argument, and hopefully the Court will allow me to argue this morning. As the Court's aware, I represent the appellee KD. Attorney Charlie Thurston, who's here somewhere, also appears on our brief, the Brevard County Legal Center, Legal Aid, Inc., and also Jennifer Paulin of the Guardian Ad Litem program is also at council table with me. She filed a brief, and if the Court allows, I'd like to give her 5 minutes of my time to address any of the issues that she wishes to raise. And finally, Florida's Children First and the University of Miami School of Law's Children and Youth Law Clinic has also filed an amicus brief in this matter. Your Honors, as the Court is aware, KD was a dependent of the state who, upon reaching majority, attempted to avail herself of the independent living benefits available through the Florida statutes, specifically the Road to Independence program. Our position is that the clear wording of the statute allowed it in her circumstance based on the findings below, and we can also address the constitutional argument. But if the Court looks at the transcript of the hearing and what was discussed, the position taken on her behalf there was that under the clear terms of the statute, she was eligible for these benefits. And to get into that argument, there are the two separate provisions of the statute that need to be addressed in 409.1451, the first being eligibility in Section 2, and then there's a more specific statute or portion of the statute dealing with services for young adults formerly in foster care under subsection or Section 5. Both of these have similar language, but they're slightly different, and as is somewhat common with legislation, we don't know exactly why that is the case, but the Court must look at the language the legislature chose to use and give it effect. Of importance to this matter, the word licensed foster care does not appear under Section 2, However, in Section 5, it does appear in a couple spots. And in that section, the court notes a dependent child was living in licensed foster care at the time of his 18th birthday, or is currently living in licensed foster care. And then the third part of that, or after reaching the age of 16, was adopted from foster care, or placed with a court-approved dependency guardian, etc. This court must assume or must accept the proposition that the legislature knew what it was doing when it omitted the word licensed from that last or that third portion of the statute. The explanation given by the department that it's common usage and everybody in this business does it doesn't change the fact that the legislature enacted a statute that omitted a word. That issue, that third part dealing with the 6 months, the trial court found in its order that she did meet the 6-month requirements under this statute. That finding has gone unchallenged. The position is very simple. She did meet the requirements of the statute. This portion of the statute dealing with the 6-month provision says foster care. It doesn't say licensed foster care.
And how do you, and what do you rely on in defining foster care?
Well, we have to look at the definition in Chapter 39, which talks about foster families, and we believe, and the position is that that definition is broad enough to encompass this. She was in the care of the state. That provision in Chapter 39 doesn't say a licensed foster family. It doesn't. It mentions foster family, and if we're taking the generally accepted definitions of foster care,
if we accepted that reading of the statute, then this spent at least 6 months living in foster care is completely meaningless. I mean, because any child who was reached 18 was a dependent child would qualify.
Not necessarily, Your Honor. I think that one of the key distinctions that the court needs to make is between familial settings, and Chapter 39 talks about familial settings where the child is placed with a family member, versus foster care, which can be either licensed or with a non-family member. The position was never taken below that every child who is taken over by the state or is dependent on the state would be subject or given these benefits. The position was that those in foster care, which is either licensed foster care...
The basis in the statute for distinguishing between placement with an aunt and uncle and placement with the best friend.
In Chapter 39, Your Honor, there's an entire section dealing with the Relative Caregiver Program, 39.5085. And I think that is, again, the distinction that was carved out of this. And so if we're talking the term foster care...
085, did you say?
I believe...
5085.
5085, I'm sorry, 39.5085. If we're, again, assuming that the omission of the word license was there for a reason, and we look at Chapter 39, which talks about foster families, then KD fits within that definition. It's the position has been below, and with Brevard County Legal Aid, that because the legislature in 39, that section dealing with relative placement, is a separate category. It's a different thing that we're talking about here. Your Honor, you mentioned earlier the legislative intent, and again, this portion of the statute that I believe you're referring to, 39.0137, mandates that equal treatment be given to children removed from their homes without regard to the location of their placement. Now, while it's a sticky wicket, that does say what it says, and I think when this case is being considered, that is one of the critical things that we're thinking about here. That's where the trial judge became hung up to some extent, saying when placement is not, it is somewhat arbitrary, it can be given different things, and you're basing these benefits or the entitlement to these benefits on that. How do we get around the, number one, obviously, this constitutional issue of equal protection, but also the statutory guarantee that appears earlier in Chapter 39 about that?
Well, the problem, Mr. Carlisle, with 39.5085 is that, particularly in subsection 1B, it seems to specifically delineate between foster care placement and relative caregiver. You know, because it says if you're otherwise at risk of foster care placement because of abuse, abandonment, or neglect, but you may be successfully placed by the dependency court in care of such relative.
Yes.
So
yes.
It talks about foster care as being essentially a different thing.
I agree.
Okay.
That's our point, Your Honor. I believe that's, again, the distinction is not between, that I believe under the statutes that we're talking about is relative placement which again is preferable. And there was an argument made in the brief, in the initial brief, that one of the reasons these benefits are afforded to people is they don't have the benefit of a familial setting, and therefore they need these things more than those given that setting. Well, relative placement is a familial setting. Whether it's licensed or whether it's unlicensed, when you're placed with a non-relative, the same reasoning applies, and that is one of the key points here, I think,
And
also.
here we have one place, she's placed with non-relative placement.
Yes. She was never placed with a relative. It was always non-relative, and so the point was, if again, we're kind of getting into the constitutional issue here and the equal protection type of concepts, but if the justification is that those who are in non-familial settings need more help, and therefore we're providing this to them, the distinction between those placed with someone who has gone through a 12-week course and has a license versus someone who hasn't is completely meaningless. There's no justification for it. And
Well,
again,
there may be no justification for it.
there's no rational basis for
Well, that's a different issue. But
Well,
do
yes.
do you agree with DCF that they're reading the statute correctly?
No, Your Honor. I mean, again, the point being that
I think that non-relative placement is the equivalent of foster care or is foster care?
absolutely. That's, again, when the
Do you have any case
legislature
law
omitted
or-
licensed foster care, it by definition, by our reading of the statutes, it had to have meant non-relative placement.
Do you have any statutes that, or not statutes, any case law that supports you on that?
There was not a lot on this. I will provide the court with some additional supplemental authority where foster care has been defined.
Is there a broadening of foster care to cover non-relative placement? I guess that's the key issue.
Your Honor, yes. There's one case, and I will provide the court with some supplemental authority, where the Florida Supreme Court found or dealt with the issue of foster care and the statutory definition in 39 and expanded it to emergency shelters and found it was broad enough there. There's another case where a court relied on a dictionary definition of foster care to find a fairly broad definition of what that means. So again, if we are looking at a pure clear reading of the statute, the omission of the word licensed and the use of the word foster care in this circumstance is broad enough to encompass the concept of a non-familial placement, which is what occurred here. If we're going to get into the constitutional issue, throughout this case and in the briefs and today, I have not heard the justification or the rational basis for the distinction that the Department claims the statute makes. In the initial brief, we see two things. We see, number one, money, and we've heard about that all along here. We heard about it this morning. And then we also heard the second argument in the initial brief was that the familial setting requires this additional benefit to be given to these children, which of course falls down because KD didn't have a familial benefit either. That justification falls. While it's debatable that the interest of the state in saving money is perhaps legitimate, nevertheless, the statute and the distinction made in the statute must somehow further and rationally benefit that interest. It's not enough to say we're going to save money and therefore we're going to deny a certain portion of the population benefits on a random or arbitrary line.
If we don't read the statute the way you read it,
Yes, Your Honor.
then at a minimum, shouldn't we send this back? Shouldn't we send it back to the trial judge to let the department address the issue by putting forth any evidence that might support their, I mean, I know that they don't have to. We can look at the rational basis test without any kind of evidence. But, I mean, shouldn't they be given that opportunity?
It's our position, Your Honor, that this does not need to go back at all because the clear wording of the statute.
Clearly, there was a due process violation. There are plenty of cases that say that if a constitutional argument is not pled, raised, made, the judge just can't raise it on his own without giving the other side an opportunity to at least respond.
Your Honor, again, I don't disagree with some of what you're saying, but our position is that because she does fit within the clear wording of the statute.
Right, I'm saying if we
the court can
disagree
affirm
there-
on that. You're saying if we disagree with that, does it require to be sent back? Your Honor, again, I think that, as Judge Stevens mentioned, the issue was waived below. It's now been briefed
How's
to
it
this
waived
court.
when the trial judge says at the end of the hearing, well, you're wrong, but I'm going to find the statute unconstitutional, and they file a motion for rehearing? I mean, I don't know.
Well, again, Your Honor, I think that there could have been some...
You didn't plead it, right?
It was not raised. That was not the position. That was
Never
not
put
the
them on
position
notice
raised
that it was
below.
going to be an issue.
I understand. I think, again, Your Honor, that based on the record, the court doesn't need to get to the constitutional issue based on the clear wording of the statute. However, if it does, I think, again, that looking at what has been raised before this court to this point, there is no rational relationship between the lines that are drawn. The amicus brief that was filed on this matter talks about the complete lack of a distinction between those in licensed versus non-licensed care, and the empirical evidence that does not allow that distinction to be made. The legislature can't offer a benefit to someone and say everybody with even-numbered houses gets it and odd numbers don't. That would save money, but it's not rationally related to any purpose. And to suggest here that those in licensed care versus non-licensed care, somehow those in licensed care are more deserving or more at need, I think is belied by the reality of this case.
Wouldn't it be a rational basis to say that children who have some kind of support, enough support that they have a home to go to with people that they know, that those kids do have support that kids that don't have that kind of network of support don't have? I mean, it's a very low standard to meet a rational basis test within no suspect class.
I understand, Your Honor. But again, if I think that's addressed somewhat in the brief that was filed in the amicus brief and then the empirical evidence, et cetera. But again, I think that the argument would be that those who have gone through a training course who are willing to serve as foster parents, as opposed to someone who just happens to live down the block, might be better served and might be more apt to provide a better situation for that child. But again, there could be evidence that could be brought forth on both sides of that. This was not a constitutional issue that was noticed for hearing, and so I do agree that that those issues could have been addressed a little more fully in a different hearing. If the Court has no further questions, I'm going to yield the remainder of my time to Ms. Paula. Thank you very much.
May it please the Court, Jennifer Paulin for the Garden Ad Litem program. There's one issue or a question that was raised prior concerning the application of benefits to children in the dependency system. And if Your Honors agree with our interpretation of the statute, the question was, wouldn't all dependent children qualify for independent living benefits? They would not, because there are dependent children that remain with their parents, much less relatives. And I would also question it's not just if the child reaches 18, that child also has to graduate from high school. So that 500 number that was quoted by the state, although it was qualified, I think would have to be examined as to what number of teenagers actually would be eligible to go to college. Additionally, the issue concerning the non-relative placements being there to support the children, I think if you poll those families and ask them, are you going to send these children to college? And if not, or will you still agree to accept these children if you pay for their college tuition? I think that would override their rational basis for distinguishing between the two, because I can't see families that were willing to take in a displaced child agreeing to pay for their college tuition.
That's not part of the record here, is it?
No, it's not, Judge, but that was the rational basis for they have these familiar.
But taking a poll of the people, I don't think is before us.
No, sir, it's not. But I think you have to be realistic on what these families can provide for these children. And the state is a much better position to do that through the interpretation of the term foster care in the statute. Apart from those two issues, Judge, we stand behind the arguments contained in our answer brief unless there's other questions for the Guardian program.
Thank you.
Thank you.
Thank you.
Thank you, Your Honors. I'd like to first address something that counsel for the Guardian ad litem just said, and she said that one of the requirements to get Road to Independence benefits is that you have to have graduated from high school. That is simply not accurate. And all that the youth has to do is to be in school full-time. Many children leave their childhood at the age of 18 without having finished high school, and in fact that is the case for many children who age out of licensed foster care, and Road to Independence provides benefits even if they continue with their high school education.
Has KD been receiving Road to Independence benefits during the pendency of this appeal?
Yes, she has.
Has it crushed the department's budget by any chance?
Your Honor, no, it hasn't, but this is not an issue about the department's budget. First of all,
You were the one that brought it up.
Well, let me explain. I obviously didn't explain it well enough. it isn't about having to pay out more money. All the money that is appropriated to each of the child care agencies, all of the agencies in the state of Florida that handle the actual foster care program, the agencies that administer the independent living benefit program, this is privatization, all of those agencies get an appropriation that flows from the legislature specifically for the independent living program. It goes to the department, and then we send it out to our contracted providers. They have a budget amount. That is their budget, whether they have...
If 39.0131 just defines foster care as care provided in a foster family and doesn't say anything about license, tell me again why we shouldn't use a dictionary definition of foster family or foster care?
Because we have the TR case that happened in 2000, that came down in 2005 from the 4th DCA. Because in 2005 we have the legislature, its staff people saying that children who age out of relative care or non-relative care are not eligible for these benefits. We have the subsequently...
Where did they say that?
That was it's in our appendix 3. On page 2 of the appendix, the committee staff talks about the present situation that the legislature was facing in deciding whether to amend 409.1451. So we've got legislative staff saying what the legislature believes their own words mean, and then we have the subsequently amended 39.013 subsection 2 saying what the purpose of the court's extended jurisdiction between 18 and 19 is, and that is for children who have aged out of licensed foster care. KD is receiving those benefits. KD herself did graduate, well, she got a GED. KD is going to college, Brevard Community College. KD's situation actually proves the distinction between foster care and non-foster care.
In what way?
In the fact that when you look at the various
You said
reports,
she was receiving benefits.
the record shows that she goes to Brevard County Community College at
in
this
this
point.
program.
She's getting road independence.
Funded by
She's getting money from the state of Florida to assist her in going to college, but she is going to college. The studies that were submitted through the Amici brief show you that children in foster care change schools so often that they're way behind in their education. That's just one piece of evidence.
That's because their placements are changed beyond they don't have any control over
And
that.
therein lies the difference, Your Honor, is
And
that
on placement, they change placement as well.
not in non-relative placement, not the way they do in foster care.
Not to the extent, but they do change placement, correct?
They may, but certainly not to the same extent.
So finish that sentence, then your time's up.
Yes, sir. KD changed placement once, and that was at her request. She actually physically changed her placement and then came back, and when we found out about it, said, oh yeah, I've moved, and now I'm with Mary. We ask that you please reverse the trial court. Thank you, Your Honor.
Thank you.
Thank you.
both.
All right.